Okay, so we're going to go ahead and get started now. I'm Bob Percival. I'm the director of the Environmental Law Program here at the University of Maryland, Carey School of Law. And on behalf of Dean Donald Tobin, I'd like to welcome you all to the formal opening of the Takings Conference. We're delighted to be hosts for the conference, and it's particularly nice to have it in this historic old church. The graveyard outside has some of the signers of the Declaration of Independence buried there, and the most famous person buried in the graveyard is Edgar Allan Poe. Baltimore actually has a very long history, at least for the United States, and the very first takings case that reached the Supreme Court in 1833, when Chief Justice Marshall decided that the Takings Clause did not apply to the states, was a Baltimore case, Barron versus Marin City of Baltimore, and it wasn't until 64 years later that the court decided that the Fifth Amendment's Takings Clause did apply to the states. When we started our environmental law program in 1987, one of the first things I did was establish an environmental law clinic, and in meeting with a lot of the communities in Maryland, it was at a time when the Supreme Court had just decided three major takings cases in 1987, the first English case, the Nolan case, and the Keystone Bituminous Coal case. And regulatory takings were really on everyone's mind at the time, and it's really an issue that has now essentially gone global. I do most of my work these days at the international level, primarily in China. And when I taught American law in China, I can say without a doubt that the most reviled American Supreme Court decision among the Chinese people is the Kelo decision, because they're subject to takings, physical takings for economic development all the time. So it's wonderful that you have this annual conference, and I'm going to turn it over now to the mastermind of it all, John Echevarria from Vermont Law School.
Well, thank you, Bob, and thank you to Maryland School of Law for hosting us here. I want to thank particularly Kate Woods and Bill Pirmatai, Mike Pappas, as well as Bob, for so generously hosting us, for doing an excellent job of getting everything organized and making my life in Vermont very easy. As many of you know, this conference wanders around the country, and some people think it wanders without much rhyme or reason. The reason we're here, I think, principally has to do with we at Vermont Law School are fortunate to have Bob Percival on our summer faculty, and at a recent summer gathering, I looked at Bob and said, "Why not Maryland?" And Bob said, "Why not Maryland?" And so here we are. Just to give you a rundown on the order of activities, there's a conference schedule which you've hopefully all seen. We are here in this room for this panel, then we will break, and then we will go to more comfortable chairs in the moot court room near the registration table. We come back here for lunch. You get the drill. The whole idea is to keep food in this room and out of the other room. After lunch, we go back to the moot court room for the rest of the day. I am fortunate to be able to hand over the responsibility of running the rest of the conference to William Lazarus, my good friend Billy Lazarus, who for the last couple of years has moderated the conference, and he's done it with such efficiency and expertise that we've nominated him for a permanent sinecure as moderator emeritus or in perpetuity, I guess, for this conference. And I'm very grateful for you for taking on that role. The final thing I want to emphasize is that this is a very serious conference, but if we don't have fun, we're really not, making good use of the time. I want to tell a story on my good friend Justin Pideaux, who will be speaking later in the day. Justin is now a rising star in academia, a recently tenured member of the University of Denver Law School. But 10, 12 years ago, he was sort of a lost soul, trying to figure out what to do with his life. And his father, who used to work at the Maine Attorney General's office and used to be very involved in this conference, brought him along to an edition of this conference in California to try to give him some direction in life. And Justin reportedly said at the end of the conference, well, if you can be a lawyer and have that much fun and get paid for it, I think I want to become a lawyer. So, you know, takings is serious business, but it's also a pretty entertaining field, and most of the people in the room are pretty entertaining. So I do enjoin you to have fun. Jokes are welcome. Light-hearted comments on disappointing Supreme Court decisions are certainly welcome. So with that, I'm done, and I again thank our host here in Maryland and thank Billy for leading us forward for the day. You're on.
So we're a couple minutes ahead of schedule right now, which will be the only time. Again, I'm Billy Lazarus. I'm at the Justice Department in the Environment and Natural Resources Division Appellate Section, and I'm one of the middle managers in my office. My responsibilities include overseeing all the appeals and takings cases, real property takings cases that the United States is involved in. There's another division in the United States Department of Justice. The Civil Division also handles some takings cases, and one of our panel members is from that division. You have this room is quite a grand room, although the sound seems to echo all over the place, even for those of us up here. To give an idea of what's going to happen, I have this cool app on my phone. It's hard for you to see down there. Hopefully the speakers will see it. It will count down their time. Everybody here is allotted 15 minutes of time, and they will hopefully adhere to that, because what we want to do is have an opportunity at the end of each panel for questions and answers. I think that Justin has probably been disabused now of this notion that lawyers have lots of fun. Justin was in our office too, so I have some stories that I could tell about Justin, but I think I'll refrain. He's back here smiling. I don't think I'd have anything as good as John's story about how it was that he became a lawyer. Actually, I do know that he was a dance major in college, so that's an unusual background for law. You have a conference schedule here. The one thing that I would mention about it is that the order of speakers on here is not the order of speakers that we're going to be using. Not that that matters a whole lot, but what we're going to do is each speaker will make his or her presentation, and then we'll have questions following that, rather than presentation questions, presentation questions, presentation questions. Our first session is in here, and that is on the nature of property in takings cases. Obviously a critical question as to what constitutes property, since the Just Compensation Clause allows the government to take property for public use as long as just compensation is paid, but that means it has to be property. And our panel is Linda Butler, a law professor at the College of William and Mary, Michael Pappas, who's an associate professor of law at the University of Maryland here, Carey School of Law, and Steve Johnson, he's an assistant attorney general and principal counsel to the Maryland Department of the Environment. So we can get going.
Good morning. In its 2015 decision, Horn versus USDA, the United States Supreme Court made two important rulings. First, it decided that real and personal property should not be treated differently, at least not for physical takings analysis. Second, it decided that the government requirement that in certain years raisin growers reserve a percentage of their crop for the government to manage and transfer was a per se physical taking. The first ruling makes sense in my mind in light of early practices, history, and modern forms of property. But it does not justify ignoring the differences between real and personal property and among the different subcategories of property. The second ruling does just that. Private property covers a wide range of resources limited only by human ingenuity. The court has posed a serious dilemma for takings jurisprudence: how to protect all types of property with a simple one-size-fits-all rule and still have sufficient predictive value for more complex forms of property. What the court misses is property's ability to evolve and provide order for emerging resources and forms. What it misses is property's richness and frontiers. Let me explain how I reached these positions. The regulatory program at issue in Horn came to be from the Agricultural Marketing Act of 1937, which authorized orders to stabilize various markets for agricultural products. One such order established the Raisin Committee to control supply and maintain prices of the raisin crop. The means used was this reserve requirement, that in certain years you had to set aside a percentage of your crop based upon market conditions. Now, raisin growers typically transfer their crop to raisin handlers, who then separate the reserves and then pack the rest and sell them in the competitive marketplace. The other crops, the reserves, are then distributed or disposed of according to the Raisin Committee. They decide how to dispose of the reserves. They could sell it, but it would only be in non-competitive markets, for example, for table juice or winemaking. The raisin growers are entitled to receive the net proceeds after deductions are taken for administrative expenses and for subsidies for export handlers. The economic impact of this act varies from year to year. The net proceeds have been distributed in 42 out of 49 of the program's history. In one contested year, contested by the Horns, the net proceeds were less than the cost to grow the reserves, and in another, they were nothing. The Horns refused to set aside the reserves and challenged the order as a taking after they were assessed a fine and a penalty. So we get to the Supreme Court. The Supreme Court, in explaining why the reserve requirement was a physical taking, stressed that the requirement involved both a physical surrender of the raisins and a transfer of title to the Raisin Committee. The Raisin Committee could dispose of the reserves as it wishes, according to the court, and therefore had unlimited discretion. The requirement also, in the court's mind, deprived the growers of the entire bundle of its rights. The interest in the net proceeds was simply too speculative, according to the court, to save an interest for the growers. And because the per se approach was being used, the economic benefits of participating in a regulated market set up to protect the value of the entire raisin crop could not be weighed against the losses of the grower, that the grower is claiming. The court's decision, I think, raises a number of perplexing questions. The context surrounding the regulation, the reserve requirement, is simply ignored. And that context is part of the management system set up to protect raisin production, to protect property use, to create value for the raisin growers so that they remain in the business. The windfalls are irrelevant. Even if only 1% of a crop was reserved and 99% of a grower's crop benefited from this protected market, those windfalls could not be considered. The complexity and breadth of property is also ignored. Comparing the seizure of a car to the seizure of a home is as was done in the opinion by Chief Justice Roberts, is too simplistic to justify adoption of a one-dimensional approach that would apply to all different forms of property. It overlooks the wide variety of assets outside of real property. It overlooks the emerging new forms of personal property that keep on developing. By applying a per se test, the court defines the property interest, in essence, as each individual dancing raisin, despite the focus of the regulatory program on the value of the total crop, on maintaining the value of the total crop. A tract of land is fixed in size. Its quantity is known. If an owner proposes to subdivide a tract into 40 lots, but only is allowed 20, the owner still has the same amount of land left after the disappointing decision. The crops, unfortunately, are not fixed in number. The yield of crops varies from year to year. The grower cannot ex ante fix the quantity of the crop grown. So this difference in variability of quantity is ignored by the court's analysis. It is ignored by this one-to-one comparison, and it should, in my mind, affect how a property interest is defined for purposes of takings analysis, a physical takings analysis here. The implications of the court's approach could be significant. Any law recognizing physical seizure or separation of a piece of personal property from its owner would seem to be a per se taking. What about California's new law adopted in 2014 about firearms, where a firearm could be, an owner could be forced to surrender his firearm if a judicial officer determines that the person poses a potential risk, even though the owner may lawfully be in possession of the firearm? Would that be a per se taking? Let's talk a little bit more about property perspectives, about property's breadth and variability. Property comes in many different forms and shapes and forms. It has a broad reach and potential for evolution. Real property is tied to the tract of land, above it, below it, on the surface. Personal property can be tangible or not, typically non-renewable, sometimes perishable, like raisins. Some real personal property is more conceptual than tangible, and its boundaries are defined through the legal system, through the legal regime. Yet, the value of that property, even though you have to go to court to enforce your boundaries, the value of that property, like software, is sometimes much greater than the costs of the litigation, the costs of enforcing. Some tangible forms of property, tangible but fungible forms of property, like raisins, are impossible. With these forms, it's impossible to identify each individual unit without physically separating the units. Physical possession has to be used there, or physical custody. And the value of that crop comes from production for sale on the marketplace, and comes from the regime that has been set up, the regulatory regime that has been set up to protect the industry. The greater the sameness, fragility, and intangibility of the property, the more the need for management and regulation by government to define the interest that is being called property. And that certainly is at stake with the raisin situation. The common law, oh, by the way, on that last page, I have to point out that dog is my little puppy, my property. The common law of property treats personal property differently than real property. It varies its principles and policies to reflect the nature of property. Possession-based rules are much more important to personal property as ways to acquire and enforce ownership. The title system is less extensive generally for personal property than for real property. Personal property often lacks the durability to justify the costs of establishing a title system. Fungible personal property, especially perishable fungible personal property, needs a more complex commercial system to handle commercial transactions in the marketplace. And we do that through our commercial laws governing warehouse arrangements and documents of title, Articles 7 and 8 in particular of the Uniform Commercial Code. Personal property has a much greater ability to evolve into new forms and assets as technological advances occur. For example, the right to broadcast began informally as customs and practices developed among broadcasters. And when conflicts eventually developed, the courts stepped in and recognized a property interest of sorts until Congress stepped in. The court's decision unnecessarily limits the nature of the property arrangement, the property management system. Instead of viewing the situation as involving a transfer of all interests, the court could have viewed it as a transfer of legal title to the Grazing Committee for management purposes. Instead of viewing and concluding that the discretion of the Grazing Committee was unlimited, the court could have viewed the Grazing Committee's discretion as limited by its regulatory purpose, just as a trustee is limited by the terms of the trust and by trust law. The differences in the nature of property and of the management systems should matter under takings analysis. A one-dimensional approach would fail to anticipate property's richness and frontiers. One size fits all was developed for tangible real property and tangible personal property that is all contained in one unit. That does not work well for other types of property, like fungible property, dependent on a regulated market for its value and not ex ante quantifiable. What we will then get is shoehorning and inconsistent results and little predictive value for the future. Thank you. Do we just leave that up? Oh, well. Put the picture of my dog.
Let's do that.
I could do that. There he is, Charlie. What?
Well, good morning. And first, let me apologize for the hoarseness of my voice and the raspiness that's afflicting what I'm told is normally a pleasing baritone. So I'd like to continue the discussion of the nature of property rights, but shift gears a bit. And let me start by framing it with a story, an anecdote here. In 2014, there was a tragic mudslide in Oso, Washington, that you probably heard about in the news, taking the lives of 43 local residents. And in the wake of that, there was a reaction among property owners in the area saying, we should never have been allowed to build here. Unfortunately, a number of natural disasters have led to similar sentiments in the wakes of floods, hurricanes, wildfires. This idea from property owners that we shouldn't have been allowed to use this property in certain ways. This is an uncommon tune to be played by property owners. Normally you don't hear a call for more regulation, for less ability to develop in the way of choosing. Normally the call from property owners is for more freedom, less regulation. So it's an odd sentiment to hear expressed from the mouths of property owners. In very different contexts, though, there are similar sentiments expressed. Take, for example, taxi medallion holders who are asking for more regulation or more extensive regulation of competition in the form of Uber drivers. Think of those who might buy pollution credits in a cap-and-trade system, who want continuance of the cap-and-trade regulation and maybe even expansion into other states. Think of holders of patents, for example, who want the patent scheme to continue and regulate largely. All of these, even though they're across a wide variety of different contexts, essentially are asserting the same idea. It's asserting some form of right in the existence or continuation or maintenance or enforcement of a regulatory scheme. So what we're talking about here is there ever an instance of an enforceable property right in regulation to take the classic takings question, the regulatory takings question, when has government action gone too far and interfered with a property right? This poses the inverse question. Are there ever instances when a lack of government action or government action not going far enough interfere with a property right or even take a particular property right? Looking at cases, this could be a very short presentation. Some cases say simply no, right? That would be less interesting. Looking at the more interesting set of cases, there actually seems to be support for an answer yes. That not only are there asserted rights in these regulatory schemes, but courts have recognized them in some areas. And in fact, I believe they've been recognized consistently enough and often enough that we can categorize them in two ways. One would be asserted rights in regulation, what I'll call appurtenant to traditional property interests. So if you think of an easement appurtenant, there's the non-possessory interest that's sort of attached to your traditional physical property. This is the idea of a regulation appurtenant, that it stems from physical traditional property, but there's some right in the regulation attached to that. Alternatively, there's also been recognition of what I'm going to call rights in regulation as rem. The regulation itself is the source of value and the asserted property right. And I'll go through and talk about why I think these exist and what defines them and be more concrete. But at the outset, I'd like to pose this, what I think is an interesting observation. Courts have recognized both as forms of property in different contexts, but they've used different standards to define when the property right exists. So, in the case of regulations appurtenant to traditional property, the standard courts tend to look at is a reliance-based standard, more akin to traditional property. In the case of regulations as rem, the regulation itself being some form of property, courts instead have not looked at reliance, but looked at legislative intent, which tends to be somewhat contrary to the way traditional property rights are recognized. So let me run through some examples of these two different categories and then try to get to some implications for the takings context and for recognition of property in traditional concepts. So in terms of regulations appurtenant, a few examples. One is in the case of asserted rights in the continuance of a water regulation regime for water law. In an Oklahoma case from some years ago, Oklahoma tried to change the nature of its riparian rights scheme. The riparian rights scheme doesn't give a right in a set quantity of water. And the Oklahoma amendment didn't do away with the riparian rights. It just said for certain rights that weren't exercised, in the future one needed to get an appropriative permit. This was challenged as an unconstitutional taking under Oklahoma law, and the Oklahoma court said yes, that even though there was no taking of a corpus of water, that the change in the regime interfered with some kind of vested right, and that that right had vested because of the age, essentially, of this law. So this is some evidence of a right in a regulatory scheme that has to do with physical property, but doesn't really implicate the physical property itself. Consistent with that, very recently, in the St. Bernard decision arising out of the flooding after Hurricane Katrina in New Orleans, You may also know of it as the Mr. Go decision. The court held that the Army Corps of Engineers' failure to maintain a navigation channel or to warn of flooding risks was a taking when flooding ensued. It created a temporary taking. And the court largely based this decision on the fact that the Corps' maintenance of this channel and construction of this channel created a reasonable expectation in property owners of continued maintenance and warning, even though they lived in a floodplain. And so the court recognized some degree of reliance on an active set of regulation, and based on that reliance, suggested there was a property right involved that was then taken. Two more quick examples. One I'll only talk about shortly because Steve is going to talk about it extensively. There's a pending Maryland case, but in an earlier procedural stage, the Maryland Court of Appeals suggested that there was a right, a property right, in the government's duty to maintain regulation of pollutants. Currently, a pending case in Washington coming out of the Oso mudslide proceeds on a similar theory to the Mr. Go claim in New Orleans. That is, that the government's land use controls created some kind of ongoing duty and reliance interest to warn property owners, prevent development, or at least buy them out in this known landslide risk area. All of these taken together fit with this idea that there's some kind of reliance-based interest in continuing government action or regulation attached to the ownership of property. And these also fit nicely with Chris Serkin's theory of passive takings, which a very interesting theory, but adds another element to this idea that there is some potential for a government duty owed based on past government actions that are going to create a reliance interest. Now note, most of these instances come out of something that was legislatively created, whether it be a legislatively creative land use zoning program, or land use or zoning program, pollution control program, whether it be legislatively created in the case of the Oklahoma water regime. The question in none of it is what was the legislative intent in terms of those. In each of these cases, the question really came down to a reliance-based question. Alternatively, in the area of what I'll call regulations as rem, asserted rights in these regulations that create a valuable interest, the court hasn't looked a bit to reliance. In fact, the court has specifically said reliance doesn't get you a property right, but instead looks at legislative intent to define this property right. So let me take some examples for you. In the case of patent, their courts have essentially held, Horn being the most recent example of an indication that patents are a protected right, protected by the Takings Clause in that case. The justification for that largely comes from the legislative language declaring these to be protected rights. The same can be said for regulated utilities, where there are protected rights recognized when there's, quote, unmistakable legislative intent. And the same analysis is applied to taxi medallions, which the protected status varies by jurisdiction, but the question ultimately comes down to, was this intended to be a protected property right or not? Conversely, in instances where there are valuable interests that bear a lot of the property-like aspects, including the all-important right to exclude, courts have found they're not protected by the Takings Clause based on legislative intent to the contrary, specifically when the legislature has disclaimed creation of a property right. Examples of this come from the ever-popular grazing permits cases, where the grazing permits are bought and sold, they're even used as collateral for loans. There's an active market for these grazing permits. They allow for an exclusive right. Courts have consistently held that Congress did not intend these to be protected by the Takings Clause. Same can be said of fisheries catch shares, or, increasingly important, pollution trading credits in cap and trade regimes. Almost, I don't want to say almost, all of which have either, that are enacted or proposed, contain the same legislative language saying this does not create a protected property right protected from takings. So what we end up with is essentially two categories of these rights in regulation that have two very different standards for determining whether or not they are property that's protected by the Takings Clause. And so in the time remaining, I just want to go through some of the implications of this. Because what this creates with these two different standards is, if not a full natural experiment, you at least get a compare and contrast situation where you have relatively similarly situated plaintiffs subject to two different regimes, and we can see how does this impact private party behavior, and what does this tell us about the relative power of courts and legislatures in this area. It also highlights one of the fundamental questions in property law, the sort of balance between stability interests on the one hand and flexibility on the other hand, which is a major undercurrent to all the takings questions to begin with. So to begin by looking at private incentives, the theory goes that there need to be stable property rights to encourage investment. And when there are not stable property rights, when they're not protected from takings, people will not invest in these interests and their value will go down. So I'll call this the value stabilization theory of protecting property. If this theory holds, we'd expect that the clearly recognized property interests, where there's clear legislative intent to recognize them as property, such as with patents, or the more reliance-based interests that are going to encourage investment, because the investment is what triggers the protection, we'd expect those would have more investment and more stable value than the clearly disclaimed interests, grazing permits, pollution trading credits, fisheries catch shares, which are expressly not protected as property. Now, I don't make any claim to empirical proof of this, but based on the surveyed cases, there's a suggestion that that's not bearing out, that there's an awful lot of investment in grazing permits and pollution credits, and that the value of other protected interests isn't necessarily stabilized. For example, one recent paper reported that patents based on recent regulatory changes are down 66% in terms of value and expected to go down another 10 to 15%. And this is a right that the Supreme Court has recently said receives taking protection. So, again, don't want to draw too much out of this, but it does raise a challenge to that idea that takings protection is necessary for stability. There needs to be further work done on this. But if it's the case that takings protection actually contributes relatively little to stability, it might mean rethinking takings protection and looking at it in terms of other values, whether they be other stability values or whether they be more flexibility values. Last point I'd like to make before letting you get on with your lives is the institutional choice also appears inherently related to this stability versus flexibility trade-off. When the court is the arbiter of property rights, when it's reliance-based, it's hard to get away from that stability framework. Whereas when it's legislature, it becomes more flexible in that regard. So that arises the question, might we shape our regimes of who identifies property based on these values? But can we? Could we shift? Could a legislature declare, we declare what property is, not the courts? Under current case law, it seems unlikely. On the other hand, could a court step in and say, we decide whether patents are protected, not the legislature? It's also a challenging question that we don't have time to talk about now, but let me let that hang out there in the air and close with the suggestion that there do appear to be rights in regulatory schemes and that they raise a number of interesting issues. Thank you.
Good morning. John asked me to talk about a specific case that I'm involved in that touches on the theme that Mike was just talking about. It's before the Maryland Court of Appeals. It's called Gail Litz versus the Maryland Department of the Environment. And it presents very directly the question of whether the Maryland Department of the Environment can be held liable for a taking where it failed to prevent or to adequately regulate against pollution caused by third parties from damaging property. And although I know Mike said that theoretically that's possible, in our case the answer is a resounding no. Let me give you the basic facts of the case are that back in the 40s, Litz's family owned some property in Caroline County. In the 60s, they converted it into a commercial campground, the central feature of which and the recreational focal point of this campground was a lake that they had created called Lake Bonnie. Lake Bonnie was fed by two streams that emanated from a small town nearby called the town of Goldsboro. Goldsboro is a small town with about 80 residences, and all of them are on septic systems that had been put in the 60s and 70s. Well, over time, not surprisingly, the septic systems began to fail. By the 80s, it was becoming apparent that the groundwater contamination was making its way into these two streams and flowing into Lake Bonnie. By 1995, MDE actually specifically documented that there were adverse impacts to Lake Bonnie from these failed septic systems. And then in 1996, the county health department notified Ms. Litz that there was a health risk associated with the use of the lake. So MDE set about to do something about this to try to solve the pollution problem, and in 1996 it entered into a consent order with the town of Goldsboro that required the town to do a feasibility assessment on what sort of public sewer system it could install to take people off of septics and to present to MDE a plan and a schedule for installing this public sewer system. Well, shortly thereafter, the town presented to MDE a study that indicated that they could not afford to build or maintain any kind of a public sewer system with such a small rate base. So they didn't comply with the consent order. And MDE concurred that the town couldn't possibly afford this system, and it never enforced the order. And one of the provisions in the order was that if the town of Goldsboro had failed to comply with any provision of the order or any deadline, that they'd be subject to a stipulated penalty of $100 per day for every day that they failed to do it. MDE did not, in its discretion, decide to impose those penalties. So ultimately, the campground had to be closed. Mrs. Litz was unable to maintain the property, and she lost it to foreclosure in 2010. So she filed suit against the state and the town of Goldsboro, alleging a variety of tort claims: negligence, trespass, nuisance, and an inverse condemnation claim. So MDE moved to dismiss all those claims, the tort claims on the grounds that she failed to comply with the Maryland Tort Claims Act, that Maryland owed no special duty to her by virtue of the pollution, and that there were statute of limitations problems. And on the inverse condemnation claim, it argued that there was no causation and also statute of limitations problems. Well, the circuit court lumped all the claims together, viewed them as tort claims, and dismissed all of them for failing to comply with the Maryland Tort Claims Act. Mrs. Litz appealed to the Court of Special Appeals. The Court of Special, just the inverse condemnation claim against the state, the Court of Special Appeals affirmed the dismissal, but on the alternative grounds that it was barred by the statute of limitations. Court of Appeals accepts cert on that question, and they reverse. So it goes back to the Court of Special Appeals. This time, the Court of Special Appeals decides that the claim was properly dismissed because she failed to state a claim for taking. Now, in her complaint, she alleged generally that the wrongful acts of the state deprived her of the all economic use of her property and forced her alone to bear the cost of accepting the town's sewage. Although she didn't specifically identify what the wrongful acts were, you could glean from the complaint that they were because the department, acting through the county health department in the 60s, approved the use of septic systems. The other grounds was that the MDE failed to enforce the consent order. And then they generally allege because MDE just failed to stop the pollution, that was the cause of the injury. So we argued at the Court of Special Appeals, based on well-settled principles in Maryland and in federal law, that there can be no taking when the act of the government is not the proximate cause of the injury. We argued straight out that nothing MDE did cause the pollution. It was caused by the use of the septic systems by the 80 residential users, and that was where the claims lay. So, interestingly, the Court of Special Appeals addressed it from a slightly different perspective along the lines that Mike alluded to, and that was, it didn't look at that whether there was a lack of proximate cause. It looked at it from whether or not MDE had some sort of a duty to regulate, and that their failure to regulate could give rise to a takings claim. And they cited a number of cases which I have summarized in the course material. And it concluded from those cases that because MDE had enforcement discretion and discretion to enforce and apply the regulations, that there could be no taking. Ultimately, it said whether you look at this case from a lack of proximate cause or you look at it from the presence of permissible discretion, there was no claim. And I wanted to just focus on one of the cases that the court cited, and it's a federal grazing permit case that Mike alluded to. And this case is Alves versus United States. It's a Federal Circuit decision from 1998. And in that case, the owner of a federal grazing rights brought suit against the Bureau of Land Management, which regulates grazing rights, because the plaintiff's neighbor's livestock was trespassing on his property and damaging his property. And so he alleged that the BLM, because they regulate grazing rights, had a duty to prevent that trespass. The Court of Claims below rejected that. The Federal Circuit affirmed that and stated there clearly can be no taking when whatever acts complained of are those of private parties, not the government. And it also went on to say that the government is not an insurer, that private citizens will act lawfully with respect to property subject to government regulation merely because the government has chosen to regulate with respect to grazing on public lands. And that surely has to be the answer in our case, that even though MDE does have the authority to regulate in the area of the environmental area, and also has the authority to specifically regulate discharges of pollution, it can't possibly be the insurer that private property won't be injured because of pollution that's caused by third parties. Another interesting case, and this also relates to the damage that was caused from Hurricane Katrina. And this case was Nicholson versus United States, a 2007 federal claims court decision. There, property owners sued the Corps of Engineers for failing to adequately design, build, or maintain the levees, and that their failure to do so was the result of the damage to the plaintiff's property. And the court, right at the outset, said that it wasn't what the Corps failed to do that caused the damage, it was Hurricane Katrina that did it. And in any event, even if the failure to maintain the levees was a factor or exacerbated the flooding and the damage, that there was no evidence that was the intended purpose of the government's failure to act. It's not as though the government decided that rather than maintain the levees, we'll just use everybody's property to store the extra water. So the court also said that in no case that we know of has a governmental agency's failure to act or to perform its duties correctly been ruled a taking. Now, there have been cases where the government has been liable for invading land indirectly. The best example of those cases are the cases where the Army Corps of Engineers constructs a dam and that results in the flooding of private property because of the creation of a pool behind the dam. And so there have been, so the courts have found that there's a taking there, but even in those cases, it's not enough just that the Army Corps action caused the damage. It also has to, the damage has to have been the direct, natural, and probable result of the activity, and that the injury was to serve some public purpose, and it wasn't just incidental. So I think in our case, Gail Litz might have had a claim for a taking if MDE, in working with Goldsboro, decided that the solution to the pollution problem was to construct some sort of drainage system to drain the septic systems into Lake Bonny. But I don't think that there's any reasonable justification for the Maryland Department of the Environment to be held liable for a taking where its role is indirect at best, as it was in this case. So we're hopeful that this case is going to go favorably with the state, for the state, because otherwise I fear that we'll just have to open the doors to the state treasury and leave it unguarded. So, thank you.
All right, this is great because speakers came in under time. And that means we have plenty of time for questions. Why don't we see what we have out here? Tekla, yeah. Just speak loud.
Right. I do have problems with the use of the per se test, even with respect to real property. I do think that it's a crude test that doesn't always, that's not easy to fit into all of the circumstances that arise and lead to takings claims. And I didn't bring that into this topic because we were talking about the difference between real and personal property from the Horn case perspective. But yes, I do have a problem with it.
John.
Right. Right. Well, I do think that the court has, despite its attempts, opened up the door to these types of claims. And under the per se rule, you do not consider the public interest. You can't consider the justification for why the firearm was taken from the property owner. I mean, literally, that's what it means. And yet, I doubt this court really thought that that would be the result, that's what they intended. So I think what the decision does is, again, show the tension among the justices about whether to use per se rules. They're going back and forth. I mean, they had the temporary physical takings case in Arkansas, where they decided not to use a per se rule for real property. Instead, to use a more complex balancing process is what they described it as. They ignore Arkansas totally in the Horn decision, don't talk about it, act as if there's only one approach for real property, a per se test. So I think there is even greater opportunity for litigation unfortunately, in this area, and there's greater confusion.
Justin.
Yeah, so I think you're at the heart of the matter, particularly when it comes to these regulations of pertinent, which comes down to a question of, well, how long does something have to be established to vest into one of these rights, and what's the power then to change it once it has, and particularly to change it non-incrementally? To try to more directly answer what are the bounds of the regulations of pertinent idea, thus far, it's hard to tell, because in terms of that, I'm trying to just sort of take cues from the court rather than advance a theory for why this exists, but I think you could ask a pretty good question as to why is this a reliance-based standard anyway? If reliance-based standards that are based on long-held common law rights are traditionally, or are thought of in traditional property rights, but when you have a set of pollution control or land use regulations that are often challenged as takings, right, then to apply that standard of reliance to that to vest into the right seems odd, particularly because they're of recent judicial vintage. So this is less an answer to your question as a sort of musing on it, because I think it does open up, why should this be the standard if the only justification is, well, this is the standard for traditional property? That rings a bit unsatisfactorily. And then just to quickly, the judicial takings question, I think particularly arises if, say you have a situation where the legislature declares something a protected property right, and the court says, we don't really think so. We don't think it looks like it. That seems to raise judicial takings much more clearly than does a change to the common law, which, presumably evolves with the judiciary, as opposed to just the legislature said this was a protected patent. It's not. So I think it's a great question, and maybe for me the best argument for judicial taking, as opposed to changing the common law, would be the override of the legislature.
Jerry, you had a question?
We have an adverse decision on that. Yeah.
I do think it's important to consider the public interest. I think it's also important to consider, but you don't get to that until you look at the nature of the property, that the property interest. I mean, when you have, I'll use his phrase, a property that, the raisins, that are part of a value stabilization program, then they are, and they're produced for one purpose, to sell on the marketplace, then, and you're benefiting from it, and 90% of your crop is benefiting, but with much higher prices, and 10% isn't, you ought to have to consider the entire crop. I think it, in terms of whether there has been a physical, you should view that as a taking. And so I would do what the justices and the dissenting justices did. That I would have considered the benefits in Horn. The benefits that, whether they're greater than the losses to the raisin grower.
The far back.
Right. Right.
So in my opinion, and my, I think these track some other folks' thoughts on even appropriative rights, with the idea that you're going to get 100% before the next junior appropriator gets one drop. Most states, at the very least, have some qualification that water rights are use rights and that there aren't actually ownership rights. So there can be a debate about that. I wouldn't view it as a taking in this instance, because the background expectation in these rights always has that qualification, in the same way you might argue that certain lands always have the overlay of the public trust doctrine, or you might argue navigational servitudes limit that expectation to begin with. So that's an answer to the question, but it's a bit of a dodge to the, does it interfere with some interest in the existence of the appropriative system as, you know, if you call it if you want to call it a pure system, I'm not sure anyone calls it that, as, you know, 100% for the most senior and then less going down the line. I could see that framed as a challenge. I don't know that I particularly buy it in that regard, because even though there are things that would support this idea of water as a property-like right, I think there's been always this qualification of the absoluteness of that right. So I think that comes into play.
Right here, yeah. Yep.
Professor Butler, I have a question for you, going back to how to calculate or how to consider that.
Yeah, whether it's a takings liability, part of the takings liability versus the compensation, just compensation. I would actually look at that more as whether there's a taking at all. And I think, you know, there are plenty of situations with natural resources like oil and gas where, you know, you now have forced pulling. You can force landowners that have an interest in oil under their property or to actually engage in forced pulling. Nobody would think that a challenge to that as a taking would be successful. Because of common pull problems, they had to share. They had to develop a different type of system. The law changed on them in terms of what they could do or how they, you know, could get their interest. And I think the same thing should apply with the raisin production. Now, this law may be out of date. There may be better ways to actually get to control supply now. I don't know about that. I think the growers will come off worse, will be in worse shape if all they said is you can only sell this much of your crop and the rest of your raisin crop, forget it. You have to hold on to it. Well, they've got physical possession, but what else do they have? No value. And you had a second part. Okay.
Chris, go ahead.
There were nuisance claims. The claims against the state were dismissed for Maryland Tort Claims Act reasons. The nuisance claims against the town, though, survive and will be litigated. Yeah, but interestingly, one of the reasons that she objected to the statute of limitations bar on the grounds that she expected that MDE would enforce the consent order and thought that we would do that. You know, she waited 15 years, but there will be nuisance claims. I mean, the town is still facing liability.
Enforcement takes time.
That's right, it does. And actually, just incidentally, just a postscript to this is that MDE continued to work to find the solution. It has taken almost 20 years, but a solution was found, and a wastewater treatment plant at a nearby town is going to be expanded to connect Goldsboro. But you know, it's hard to find the money for these projects out on the Eastern Shore. I actually had a
Sure, go ahead. Go ahead.
A question for Mike, and that is that in our case, the Court of Special Appeals found that MDE had permissible discretion. It didn't have to enforce the consent order or take affirmative action. But the question I'm wondering is if the court had found that there was in fact a duty to do something, and we did not. Whether that's more akin to a tort claim rather than a taking claim, because it's important in Maryland and in other states there's a damage cap to tort claims, but not for the takings claim.
Yeah, and I think certainly that this whole set of cases, anytime there's a duty in government action, I mean that's using tort terminology even, and so that blurring does occur and is important, as you say, for these damage reasons as well as potentially others. Now, you know, the blurring of tort and property, we talked a bit last night, has existed for a while in terms of nuisance. Certainly, so that leads to another, obviously, issue that arises from this is, does this create some more procedural bar or a damage cap? If there is a damage cap, can it really be said to be a takings claim? Because that will possibly limit just compensation. And so there do you get some kind of tension between the damage cap and the Constitution in terms of just compensation. On the other hand, there are property elements that do blur with tort in other ways. So in terms of lease law, the idea of caveat emptor has been limited. There have been these warranties of habitability that impose tort-like duties. So it's not completely foreign to the realm of property, but I agree that once you get into the detail of that, you have to answer a lot of these questions where doctrines weren't meant to go together. And to kind of bang the drum I've been banging, if the reason you get into that scheme is purely based on what the property owner relies on and not what the government intended or what the legislature intended, it potentially raises a lot more of these conflicts than if you could fall back on this was never intended to create that right or to create a duty, which is the idea of discretion to begin with.
All right, we're at a close. I just wanted to make one comment, which is that the reliance on the grazing cases, I personally find interesting, just because to me there is really no question in those cases, and it flows really from the use of language. It was puzzling that somebody on the government side would use the term grazing rights. It's not grazing rights; it's a grazing privilege.
Same thing could be said about water.
People are being allowed to use the public lands,
Yeah.
and the government has full right to withdraw that at any time. And so there really can't be a taking in that situation because it's not a property right. It says so in the statute as well, but even if it didn't say so, the scheme is a permissive use of public lands. It's not a... Now, there is an odd expectation that has developed where the grazing privilege is seen by banks for mortgage purposes as being the equivalent of a property right. That's a problem from their side. It's not a problem from government taking side. But anyway, we will be moving this to a different location. Now we have a short break, and I'd appreciate it if everybody's there on time, but we'll begin again at 10:30, and that's in the moot courtroom, which was just to the right as you came into the building. It's a very nicely set up room. Thanks.
Riparian rights are actually viewed as property rights in state in East. I think
They're viewed as tied in with
One quick announcement from the school.
Yes, one quick announcement. It is called the ceremonial moot courtroom, but it is actually a fully functioning real courtroom. The Maryland Court of Special Appeals will be here next week to hear cases. So I ask all of you to treat it as such. Please, no food or drink other than water in the moot courtroom. Thank you so much for your cooperation.